If a lawyer tells you that an appeal to the Court of Appeal is straightforward, easy or in the bag, they either lack experience, candour or both. It's notoriously difficult to overturn a jury's verdict. A jury's verdict and the sanctity of it is the very cornerstone of our criminal justice system. I'm asked on many occasions to review cases that people want to appeal, often on behalf of families or the defendant themselves. One of the worst lines I hear is, "I wish I'd come to you sooner," but lots of people are in that situation. Their trial didn't go well, it went badly, and they end up being convicted. To successfully appeal, it's not enough to say, well, something went wrong at the trial. For example, you could point to the judge's summing up and say, well, the judge got the law slightly wrong or didn't summarise the facts fairly, and you might be right, but it's not enough in itself to overturn the conviction. The Court of Appeal will only look to see whether the conviction is safe. So something can still go wrong, but the conviction be safe. When I'm asked to advise on an appeal, I need to read all of the papers in the case that were served on the original legal team, all of the papers that were generated by the legal team, and also the transcripts of the evidence given and the transcripts of the judge's summing up. We have to identify something that went wrong to the extent that we could argue in the Court of Appeal that the conviction should be deemed to be unsafe. And that is a notoriously difficult thing to do. One thing that lots of weak lawyers do is to say, well, there are some grounds here that we could argue. I think that's totally wrong. In a situation where somebody has been convicted and they're looking for advice as to whether or not they have grounds to appeal, I don't believe it's right to charge people for false hope. And sometimes the advice is negative. It's difficult advice to give, but it must be given fairly and squarely to family and the defendants so that everybody knows where they stand. On the other hand, if there are grounds, then they must be properly argued and put before the court. And this can be done sometimes many years after the event. There has to be a reason for the delay. Sometimes it's fresh evidence that comes forward that wasn't available at the time. Sometimes it can just be a new lawyer having identified something that went wrong many years ago that was missed by all at the time. And I have been involved in cases involving both of those issues.